Well, we like to be punctual, and I have 7 o'clock, so I'll go ahead and get started with getting your affairs in order. This is the first of our 4 webinars for this year. We have a good turnout tonight. We're glad you're here, and we hope that you get a lot of good out of this webinar. If you registered in advance, then you should have received a goodie package from us, which included, among other things, this booklet that you can use as you prepare to get your affairs in order. Our goal for this evening is and I think Kim is going to share a PowerPoint while we proceed. Uh, our number one goal is really to encourage everyone watching this to have a will made. Um, we know statistically that there are a number of people probably on this call who have been thinking you need to get a will, but you've been putting it off. And so that's really our number one goal, to convince you that yes, you really should take the next step toward getting that will completed. Um, and what we're going to do to begin with is help you get ready for that visit to your lawyer. We'll discuss not only your will, but the other important documents that you need besides a will. And then we will talk about how your will and your estate plan can be a Christian witness by sharing with you some of the more common tools of planned giving or legacy giving for making gifts for ministry. So the first step toward getting your affairs in order is to take an inventory of what you own. And you could use a notebook, or you could use the booklet that we sent to you, and just begin to list all of the things that you own. Make a list of any real estate, the house you live in, any vacation home or second home, and what is the interest that you own in that? Meaning, do you own it outright in your own name, or is it joint property with your spouse and some other person? And that's important because if it's joint property with the right of survivorship, then the survivor gets title to that property when you die, uh, irrespective of the will or living trust. You might list also sources and amounts of income that you receive from salary or wages, Social Security, retirement, pension, all of those things that pay money to you periodically. That will be helpful for your family after your death. List any significant personal property that you own. Uh, Cars, boats, RVs, campers, jewelry, guns and tools and antiques and furniture, all those types of more major personal property. List any life insurance that you have, including the policy number, maybe the company, the telephone number of the agent, and beneficiary information. List all of the bank accounts, and again, the ownership interest, whether it's a joint account or an account solely in your name. You'll want to include account numbers, and if there's online access, you might include your credentials, meaning your username and your password. The next thing to do is probably to make an inventory of what you owe: your mortgage, your car payment, credit card payments, medical bills, utility bills, any other kind of outstanding bills. Again, this is helpful to your survivors after your death to help wind up the affairs of your estate. Other important information that you would want to include before you visit your lawyer is, of course, your full legal name, your Social Security number, your date of birth and your place of birth. names and addresses of your family, your employers. And I think it's a good idea to list all of your employers because your family might want to reach out to see if there are any benefits that might be available from long ago employers. Military records, any religious contacts, the name of your church, the name of your pastor, perhaps contact information for the pastor. If there's a lockbox at the bank, you would want to include the location of the bank as well as the location of the key to that lockbox. And then other important business and family contacts that you can think of. And then the last bullet here is to remember that nowadays we have digital assets. And so it's important to list that, and you might include social media accounts as well as usernames and passwords and what you would desire to be done with those, such as your Facebook or Instagram accounts after your death. Personally, I want my survivors to download any pictures they want, but then I want them to close those accounts. I don't want people to be reminded of my birthday every year. And I know a lot of people who are long since deceased. I get reminded occasionally that it's their birthday. And my preference is just to have those accounts closed. But you have to think about all of those kinds of things now. The next thing to think about is who are the objects of your affection? Kim said after we put this PowerPoint together that no one but a lawyer would ask, who are the objects of your affection? Well, all that means is who are the people or charities that you would want to see inherit your property. For most people, it's their spouse, children. Sometimes there are close friends who we might want to inherit something from us. Caregivers are sometimes included, and your church and other charitable organizations. Just list those out so that when you talk to the lawyer, you don't forget to mention anyone that you had thought of. So, what are the documents that you need to be considered having your affairs in order? The first thing you would need is a last will and testament. And as I said, that's really our number one goal, is to encourage everyone to have a last will and testament. Sometimes some attorneys may encourage you to have a living trust, and that would depend on your circumstances. But even if you have a living trust instead of a will, you also need a will. In addition to your will or living trust, we would encourage you to consider having durable powers of attorney for medical and financial, as well as a living will or advanced directive. And we're going to discuss each of these. So the first document is your last will and testament. This is, I think everyone thinks of the will as being the document that directs what happens to your possessions when you die. And that's true, and that's certainly one of the important purposes of a will, but there are other things about it too. In your will, you direct who administers your estate when you die. And if you don't have a will and don't name an executor to wind up your affairs, then really anyone with an interest in your estate, which often means a creditor, can come in and administer your estate. And I think most people would rather have a trusted family member or an attorney to go through that process. So that's another reason to have a will. A third reason is because in a will, you can nominate who can become the guardian of any minor children that you have. If you don't have minor children, that's not something you need to worry about now. But if you do have minor children and you don't have a will, then a court is going to decide who would have custody. And you will have no opportunity, if you're dead, to make any kind of nomination. So it might not be the person or family that you would want to be the guardian. So that's another important reason to have a will. In your will, you can make gifts to your church or other charities. If you don't have a will, the state is not going to assume that you would have given a gift to your church or any other charity. So the only way to make a bequest to a charity is to include it in your will. And then I have a point here that says to pour over into your living trust. And this is for those people who have a living trust that's kind of their dispositive agreement rather than a will. They still need a will for any property that they haven't titled in the name of that living trust, just to catch anything that might have slipped through the cracks and isn't titled in the name of the living trust. So that's why I say if you have a living trust, you still need a last will and testament. If you don't have a will, then the state, whatever state you happen to live in and have assets in, has a way of determining who are the heirs who will be receiving the contents of your estate, and it's figured on marriage and bloodlines. So it's not going to take your intentions into account. It's just the rule for every person, and it's along bloodlines essentially. And then finally, another reason to have a will is because it's your last opportunity to give a Christian witness. And we do call this a last will and testament for a reason, because it's a chance to give a testimony. So your will can literally include a Christian witness, and I'm going to give you an example of one of those. And then your dispositive paragraphs in your will, the way you're giving your money away can be evidence of that Christian witness. The next document we would encourage you to discuss with your attorney is a durable power of attorney. And it's called durable because it doesn't become ineffective when you become incapacitated. In fact, some powers of attorney can be called a springing durable power of attorney, which means it only becomes effective when you become incapacitated. But whether it's immediate power of attorney or a springing power of attorney, you would want to have a durable power of attorney that remains effective in the event that you're no longer able to make decisions on your own. And there are essentially two kinds of these. The first is a medical power of attorney, which everyone should have, and your medical providers would want you to have this too. It gives someone power to make medical decisions on your behalf if you become unable to make those decisions on your own. And I can tell you from personal experience that having this document is a huge help to family when difficult decisions have to be made about life and death of a loved one. If they have done an advance directive, which I'm getting a little ahead of myself, which lays out their wishes if they become in a persistent vegetative state, and if they've given someone power of attorney, then the family and the ones with the power of attorney can act with confidence that they are following the loved one's wishes. And in a very difficult time, that makes it somewhat easier to at least know that you're following the person's wishes. Then the other kind of power of attorney that's important to have is a financial power of attorney. This can be a broad power that gives someone you trust the power to make all kinds of financial decisions, such as the power to buy and sell real estate, the power to make mortgage payments, the power to open and close accounts, the power to sign virtually anything on your behalf, um, to be able to transact business when you are unable to. Or it can be a more narrow power of attorney that's given for a specific act when you're just unable for a short period of time to complete something. But these are important documents to have, and we encourage you to discuss these with your lawyer when you make your appointment to do your will. The next document, which I mentioned, is a living will. This is also called an advance directive. And this is something that you would complete now while you're not incapacitated, where you can give instructions about any end of life care, and you can give detail about the types of medical treatments that you approve and what you would rather have withheld from your care. You can decide in advance whether and under what conditions you want to be taken off life support. As I mentioned, having this document in place is a tremendous gift for your loved ones when they're in the position and the palliative care team is coming in to meet with the family. If you already know what your loved one wants, then that makes those difficult decisions somewhat more bearable. Okay, so we've gone through all of these documents. We've made all of these lists. We've visited our lawyer. We've completed our will. We've visited the lawyer a second time and had the will signing. Now we've got all of our documents. Our affairs are in order. Now what do we do with them? Put all of them in one place, in a safe place. I recommend keeping it at the house. If you have a desk in a particular drawer or in a waterproof, fireproof home safe, these are available at any kind of a big box store. And make sure someone knows where the key is or the combination. I don't really recommend keeping it at the bank in a bank deposit box, but some people do keep their important papers there. You just have to make sure that a copy is left at home and that someone knows where the keys are. It can be difficult after a death to convince the bank that you have a right to get into the safe deposit box if the will is in the safe deposit box and you can't get to the courthouse to get the authority that you need to transact business. That's why I think if you have a safe place at home, that's probably the best place to keep it, and not the bank deposit box, safety deposit box. And make sure you tell someone you know, perhaps the person who's going to be the executor, where the papers are, and keep them there. I encourage you to review them and update them periodically, because you're going to probably have new accounts and new assets from time to time. So you want to make sure you keep them updated. But always put them in that place where your trusted executor or family member will know where to find them when it's time. Now, I mentioned that your will can be your last opportunity to give a Christian witness. If you've ever seen a will or seen a movie that has a will reading in it, you know that the will always sounds pretty much the same. In the first paragraph it says, "I, so and so, being of sound mind and disposing memory, do hereby make and declare this to be my last will and testament, hereby revoking all other wills and codicils by me heretofore made. Well, instead of that legalese, you could have a Christian preamble. It becomes a public document when it's filed at the courthouse after your death. And first of all, for your family who is reading this will, they get an idea of what has motivated the way you've lived and what has motivated the way you are making your dispositions from your estate. And then it's a witness for anyone who happens to be in the courthouse looking through that particular will book and happens to see it. So this is an actual real preamble from a will, and you're welcome to copy that or use part of it or use it as a guide. When you're getting your affairs in order, this is an excellent time to consider whether you want to leave a legacy for ministry. So during your lifetime, you've supported your church financially and with your prayers, your presence, your service, and your witness. So some people like to continue giving financially to their church after their death. And the time to think about that is while you're getting your affairs in order. So a planned gift or a legacy gift, they really mean the same thing. It allows you to continue to support your church after you die. And so I'm going to turn it over to Kim now, who will share with you some of the most common forms of planned gifts.
Hey,
And
Jeff, before you leave, we have several questions so we should probably answer now that seem to fit really well in the first part of the webinar.
Sure.
Our first one is it true that you don't need an attorney to prepare a will in West Virginia?
Well, first of all, I should have said earlier that nothing that we share tonight should be considered legal or tax advice. While I am a lawyer, I'm not your lawyer. It is true that you don't need an attorney to prepare a will, but I think that I don't know, it's attributed to Abraham Lincoln. I think that you don't want to have a fool for a client. And that's a bad interpretation of his quote. But the thing about a will is it's not only the words that are in the will, but it has to be executed properly. And that is as important as the terms that are contained in the will, because if it's not witnessed and notarized exactly properly, it could be held invalid, and then it's the same as if you didn't have a will. So I wouldn't encourage anyone to do a will without an attorney. I think it's your legacy for your family and for anyone else that you love and care for, and I think it's worth making sure it's done right with an attorney.
Next question. How can we list a particular foundation account as our beneficiary through Wespath? And I assume we're talking here about retirement.
Yeah, well, the best way to do that is to get in touch with us ahead of time, and we can give you the proper name and account number that you could use.
And do you have any recommendations for people who are single and living alone?
Recommendations for that's a fairly broad question, but in terms of whether they need a will, something is going to happen to their estate when they die. And if you're single and living alone, then that's probably a situation, if there's not a close family member, that's probably a situation when a creditor is going to come in and become the administrator of your estate. After a certain length of time, if no close family member goes to the courthouse, then any interested party can do it. And so your estate will be distributed according to bloodlines. So to parents, children, siblings, cousins, and then, on out. And if you've ever tried to buy a piece of property that has been tied up in an intestate situation where there are lots of heirs, it's really hard to tie up any loose ends. So I would encourage a person who is single and living alone to consider making charitable gifts. I mean, certainly make any gifts from their estate to close family and friends. But it sounds like the perfect situation for an estate that would be charitable. And so you can support many charities or one charity. I know I talk to a lot of people who the church is like family to them. And so it's very natural for them to want to support their church. I hope that helps answer the question, and I would encourage the person that asked it to feel free to follow up with me individually later.
Our next question, what if you dare not leave anything to relatives directly because it would be problematic for their Social Security disability supplemental? Can assets be willed to a trust to be managed on their behalf?
Yeah, that's an excellent question. And that is definitely something that you would want to discuss with your attorney, because there are ways that you can protect the money from the person who would lose benefits if they received a legacy gift. Good question.
And then we have another one. When you have an IRA, you are asked who the person is that will receive your IRA assets upon your death. My question is, what has priority when there is a conflict in names? Does the will trump an IRA in naming your benefactor?
The IRA beneficiary designation trumps the will. I believe that's the case. And I don't know whether that's specific to West Virginia, and I should qualify it that way, but I believe it is the IRA designation. Anything that has a beneficiary designation, that takes precedence to the will and is actually done outside of the probate process.
My one other question, and this isn't in the chat, but could you tell those with us when a durable power of attorney ends?
A power of attorney, a durable power of attorney, ends at death. That's a good question, because some people think if they're the power of attorney, they can just continue acting as such after the death of the decedent, but it ends then. And then the executor is the next person who has authority to act. The executor is named in the will as the person who will wind up the estate. And I probably should have put this in the PowerPoint. When a person dies and you're the executor, what you need to do is get the original will and a death certificate. Usually the funeral home will help you get a death certificate. You'll need to take those two documents to the county clerk, and the county clerk will give you it's called letters of administration, and it's the authority that you will need to show to all of the banks and everyone that you're going to be transacting business with on behalf of the person who died. So
that's why if you have your will in a safety deposit box, you aren't the executor yet because you can't get to the will, and you're no longer the power of attorney.
Right.
Okay, I think that's all the questions we have right now.
Great questions.
They are. So keep putting those questions in. We'll have another Q&A time at the end. And we look forward to hearing your questions. So the first thing I want to talk about is the most common type of planned gift or legacy gift, which is a bequest. And we've talked about wills and why you need wills and what they mean, but let's talk about a charitable bequest or a bequest. A bequest is a gift that is established by a provision in your will. And it's the easiest way to make the biggest gift, because when the will is executed, you no longer have need of the assets that are being given to other people. It's revocable, which means it can be changed. So if you have a will today, you can go back later and do a codicil or have a new will drawn up, because a will is revocable until your death, which is one of Jeff's jokes. It's no longer revocable after you die. A will can be for a specific dollar amount. I give my Aunt Betty $10,000, or a percentage. I give my child 20% of my assets. It can be for a specific property. I give my diamond necklace to my daughter-in-law. And it can be contingent, which means I want this to happen. I give this to my wife unless she has predeceased me, which is the contingent part. And then I want this to happen. It can be residual. A gift can be, for example, if it's a charitable bequest, you may have a list of things you're leaving to your children or your friends, and then if Jeff were doing this, he would know the 3 words, but it's the rest, residue, and remainder of your property would go to the residual beneficiary, which might be your church or the foundation, just everything else. And the great thing about a will is that you can take care of your family and your charities, your friends, your charities in the same document. You may consider your church to be like your family. So if you have 4 children, you may divide your estate 5 ways. So you're taking care of your children with each 20% of your estate, and then 20% of your estate to your church. Or maybe you've always been a person who tithes, and you might tithe 10% of your estate to a charity or your church or the foundation, with the rest of it taking care of your family. So a bequest has lots of flexibility, and it is changeable, which are some great characteristics of a bequest. So a bequest and your will goes through probate, but there are things that happen with your assets that do not go through probate and are done outside of your will. The first we've already talked about a little bit, they're beneficiary designations. So anything you have where you list what happens to the assets upon your death is a beneficiary designation. So it could be a life insurance policy or a retirement account. There's a form you fill out that designates what happens to the assets in the life insurance policy upon your death. That's a beneficiary, and it transfers outside your will. So it doesn't have to wait until your estate closes. It transfers before that usually. The interesting thing about life insurance, well, retirement accounts, let's focus on retirement accounts, is that the assets that transfer to a person, say your son or daughter, upon your death from your retirement account are taxable to them, whereas assets transferring from your will are not taxable to them. So if you're trying to decide, in my example of tithing 10%, if you're trying to decide which assets should go to the church and which to your children, you may want to use the retirement assets as your charitable gift, and the assets through your will as gifts to your children, because then they wouldn't have to pay taxes on it. Joint property that has right of survivorship. I'm sorry, something is getting in my throat. For example, my husband and I own our house together. We have joint property rights with that. When one of us dies, the other will own the house, and that does not flow through our will. That's a joint property with a right of survivorship. There are things called POD and TOD accounts. A POD account is a payable upon death account, and that's usually a bank account. So you work with your bank to set that up, and there's a contingency in that upon your death, the assets in that account transfer to the person you're naming in that POD. the beneficiary of that. A TOD is much the same thing, except it's used for investment accounts. So if you have investments at your financial advisor, you may have a TOD account where you name your beneficiary on that account as the person who receives those assets upon your death. And then in West Virginia, you can also have a deed that transfers upon death. So there's a part of that deed states where the property will transfer upon your death. Another legacy giving type instrument is qualified charitable distributions. We often call these IRA rollovers. This is something you do during your life. It's for donors who are at least 70 and a half years old. Donors who are that old and have an IRA can transfer up to $105,000 directly to a qualified charity, such as the foundation. There are no tax consequences to that distribution. So if you have an amount that you need to have as a minimum distribution, that can be used as a rollover, a qualified charitable distribution. So you would not pay income tax on the amount rolled over, and there's also no charitable deduction for the gift to charity. This is something that started when Katrina happened. If you remember the hurricane that hit New Orleans, this is something the government put in place to help encourage charitable gifts for disaster relief. And almost every year since then, it has been kept as a way people could make a gift without a tax consequence. And now it's been made permanent, or as permanent as something can be when it involves the IRS. The one caveat here that's very important is that it must be done directly from your IRA administrator to charity. It can't be money you receive from the IRA that you then give to charity, because once you receive it, it's income for you, and it is taxable. So if you're interested in an IRA distribution, contact us and we can help you understand it further, but you'll need to do that through your IRA administrator. There is a particular caveat that can be done now that's very new. You can create a charitable gift annuity, which we'll talk about in just a minute, using a qualified charitable distribution. You can do it one time in your life for up to, it's a little over $50,000 to create a charitable gift annuity or a charitable remainder unit trust. And we'll talk about both of those. But just keep in mind that that could be one way you use a qualified charitable IRA distribution. So let's talk about charitable gift annuities. A charitable gift annuity provides income during the donor's lifetime. So the way it works is that a donor makes a gift to the foundation, and there's a contract that we sign about how that money will be handled. Part of the gift returns to the donor each year at a rate based on the person's age. It can be two people, so it can be two ages. And I'll show you those rates in just a minute, but it's, if you give, say, a gift of $100,000 and you're 80 years old, I think the rate there is about 10%. So each year you would receive back $10,000, and part of that would be tax-free. Excuse me. Those payments are guaranteed for one person or for two lifetimes. It's not an investment. It's a rate based on your age at the time of the gift. And even if the original gift is depleted, the payments continue. They are designed, though, with a rate that should, doing actuarial calculations, is probable to leave a gift of about half of the original gift for charity. So you make the gift, you decide on the charity you'd like to benefit from the residual, and then at your death, the rest of the original gift and the growth that is remaining in it is transferred to the charity that you have chosen. So it's a way to make a charitable gift and to receive income payments back during your lifetime. You do receive a charitable contribution if you itemize for the year of the gift. And as I mentioned, part of the annuity income is tax-free. Here are the rates for charitable gift annuities. Now, these do change from time to time. These are the current rates. And the tax-free portion can change as the federal rate changes, but this is May of this year. And we won't go through all these numbers. I actually said an 80-year-old, it's a 90-year-old who gets a 10% rate. So let's look at the 90-year-old, a 10% rate. So an annuity of $1,010 each year, which can be received in one payment or 4 payments or 12 payments, depending on how you want it. We'll divide it however you like. And of that, about $1,000, $767 is tax-free. And the charitable deduction when you make the gift, this is a one-time deduction, is a little over $6,000. So that's how charitable gift annuities work. And if you're interested in those, give us a call. We can do a personalized proposal for you that you can read about and take to your financial advisor or attorney and consider with your family if that's something you'd like to do. Now they are gifts, and they aren't, I mean, they aren't returnable. So we've had that question before. Another kind of account is a charitable remainder trust. It's a little bit like a charitable gift annuity, but it also offers more flexibility than a gift annuity does. A charitable remainder trust can be work a lot like a charitable gift annuity. Those are called CRATs. So those have a fixed amount of income that never changes. So if you open a CRAT, you might have a payment amount of 5%, and it will pay 5% every year, that 5% of the original gift every year. The other kind is a CRUT, and that stands for a charitable remainder unit trust, and that's a fixed percentage of income. So a 5% charitable remainder unit trust would pay 5% of the value of the account at the end of the previous year. So as the account grows, the payment you would receive from a charitable remainder unit trust or a CRUT could increase or decrease depending on the market value in the account at the end of each year. They can be for life or a term of years, and donors can add to it, to a CRUT. You can't add any additional gifts to a charitable gift annuity or to a CRUT, but donors can add to a CRUT to increase its value as you choose to do that. And there are some tax advantages to a charitable remainder trust. The next one we wanted to talk about is a donor advised fund. Consider a donor advised fund as a way to make one gift and then give advice on how that gift is distributed. So you get as you make the gift, you then have the authority to give us advice about the distribution. So for example, there's a couple that's created a donor advised trust at the foundation. They wanted to have that fund and have it grow with the foundation and then be able to give advice on gifts to their church from it. So maybe the church is doing a renovation on their social hall, and 5 years or whatever since the family created the donor advised fund, they can then call us or send us an email and say, I'd like to send money from my donor advised fund to my church for this project. That's why they created donor advised fund. We have another donor advised fund at the foundation that sends a certain amount of money each month to a particular charity that the donor wants to support every month. And so you get one contribution, charitable contribution deduction each time you make a gift, but then we take over and help you to do that charitable giving. Now it is advice because you have given the money away, but as long as it isn't contrary to our mission, we would take your advice and make those gifts. Your initial gift and any additional contributions are tax deductible, and it's a way to support churches and charitable organizations that you want through that donor advised fund. So we have one donor who has a donor advised fund. She sends us a list of gifts to make twice a year to charities she wants to support, including her church. So it's a way to take care of several charities with just an email to us. And those charitable funds can grow over time as they're invested in our investments with the foundation. So that's lots of different kind of plan gifts, and there are even more that we haven't gone over tonight. So you may have the question, what plan gift should you choose? Really depends on your individual circumstances. When I started at the foundation, Jeff described the work that we do as very much cross-like. So we're matching the donor's need to give, because we're all called to generosity and we have a need to give, whether it's through our estate or through our living gifts. Where does that intersect with the need of the world? Where does the world need your generosity? And what tools would be the best one in your own circumstances to make those gifts? And that's something at the foundation that is part of our mission, to help people find that place where their need to give and the world's need to receive intersect, and what tools are best to make that gift. And it's a great sacred place to be. This is our contact information. If you have additional questions, we hope that you will be in touch with us. You will receive an email. It may be Tuesday after Memorial Day, but it will have the slides and a lot of different resources that we've talked about tonight. If you're anxious to get that, you can go to our website. I put the link in the chat. There is a webinar page that already has resources loaded for you. You can download some forms for medical powers of attorney and living wills. You can, Jeff's preamble is there. Lots of different links that you can check out that we talked about tonight. And if you are an officer in a church, there's several links there to resources you might consider using in your church as you talk about legacy giving. We have more questions. I haven't looked at the chat since I started talking.
Yes, I see a question here that I'm just going to read as I go. If I wish to fund an endowment to be administered by the foundation with the residual of my estate, that would be donor advised, in that it would be specific to use. Does the account at the foundation need to be established prior to my death, or can it be initiated upon my death? That's an excellent question. Technically, a donor advised fund is done while you're living. An endowment that you would create at your death at the foundation would be more like a donor directed fund. I mean, you would tell us in the endowment agreement where to distribute the annual net income or whatever distribution rule you would want to put on that, and where to send it, what ministry or church it would support. It doesn't have to be created prior to your death, but we really prefer to have an agreement with the person while they're living, so that we have a clear understanding. We often do get surprises. We just received notification that we've been remembered in someone's estate. But unless it's a very specific bequest that tells us what to do, we may not know. It might be a person that we haven't had a close relationship with. So we encourage you, if you're considering creating an endowment at your death, to let us know and let us help you get it established ahead of time. You don't have to put any money in it. You can fund it with as little as $1,000 during your lifetime, or it can just be an agreement that's in place that would receive a gift at some future point, or a planned gift at your death. I hope that answers your question. And for any of you whose questions I haven't fully answered, please feel free to call us or email us, and we'll follow up with you.
The other difference between a donor advised fund and an endowment is a donor advised fund, the donor is giving advice to us about what to do.
Right.
In an endowment, they're placing a restriction. That's not advice, that is instructions.
Right.
So it's a little different.
Yeah. There's a question about this. Is this recorded for viewing by persons who did not get to attend? And yes, it is recorded, and it'll be on our website. Will they get the link in that email you mentioned? We
will include the link to the recording in the email that we send you, and it will be stored for, I don't know how long, a long time on our website. So you can always go back and find it on that webinar page on our website, which is umfwv.org/webinar. getting your estate in order, I think. I put it in the chat though, and it will be in the email we send you. If you go to webinars, you'll find it. umfwv.org/webinars. And there are other webinars there that you might find interesting, so take a look around.
And there are other webinars coming up as well.
That's right, there are. Our next one is in July, and it'll be on investing with the foundation, more a church or charitable charity type focused webinar. And that one will be a little different because we're going to allow a lot of time for questions. We'll talk for 15, 20, 30 minutes and then open the floor for questions. So it's kind of an ask the foundation. Maybe you can come up with some questions we can't answer, which would be great because then we do some research and get back to you. But that one's in July. We have Ken Sloan join us in September to talk about stewardship programs, planning your stewardship campaign. And then December, Meredith McNabb will talk about telling the story of your ministry. People give to ministry, they don't give to budgets. So how do you tell the story of your ministry? And that's part of our year-end stewardship extravaganza for the year. Every month has a theme, and those all fit in the theme. But I hope you are subscribed to our monthly email. You'll get all the information you need for all those webinars plus more.
Well, if there are no other questions, I hope you've enjoyed the presentation, and I hope that you're encouraged to quit procrastinating and get your affairs in order and get that will done. Your loved ones and the other objects of your affection will appreciate it, and you'll feel better about it having it done. Thank you.
Well, procrastinator. It's great to see everyone. Thank you so much for joining.
Good night. Happy Memorial Day weekend.